We've got some pretty seismic legislation appearing before Parliament today. It's been a very long time coming. It's been in multiple Conservative manifestos. And I suppose my first question to you, Deputy Prime Minister, will be why is it that the day before two pretty crucial by-elections do we finally get to see details of the British Bill of Rights?
Well, actually, I published the consultation document with the policy outline and indeed text on clauses in December, so it's not the first time. But we said at the time we'd move to a consultation, I think that's the right thing to do, and then publish the bill around now to allow second reading, as it's called, the first big debate in Parliament before the end of July and the summer recess. And what this bill will do is it will replace the Human Rights Act, reinforce our quintessentially British liberties like freedom of speech, the liberty that guards the others, give it higher pecking order in the hierarchy of rights, greater weight attached to it. I think that's important. But also curb some of the abuses of human rights that we've seen with very elastic interpretations fuelled by the Human Rights Act, which, just to give you an illustration, have allowed foreign criminals to trump deportation orders with very opaque, elastic interpretations of things like the right to family life. And that's the kind of common sense approach that will restore to our justice system.
Now, you first proposed a British Bill of Rights all the way back in 2009, well over a decade ago. The Conservatives have been in power in one form or another now for 12 years. Why has it taken this long?
Well, I wrote a book about it in 2009. You're right, it was a manifesto commitment in the 2010 election. And when I was Justice Minister in 2015, we prepared a consultation on it, but it was interrupted by Brexit. Now that Brexit is delivered and we've dealt with that issue, I think it's right that we restore some common sense to our human rights regime. And so we're staying in the European Convention. I think that's the right thing to do. I don't think we need to leave it, and indeed leaving it wouldn't really solve many more of our problems. But we will stay within the Convention, overhaul the Human Rights Act, and that gives us much greater leeway, margin of appreciation over the application of rights. And in particular, there are areas where we want to strengthen liberty, freedom of expression, freedom of speech. But there are also areas where we want to be able to protect the public. My parole reforms, dealing with the threat of ideologues and terrorists inside prison. And of course, as I've already said, deportation of foreign national offenders. So we'll get the balance right, protect our proud tradition of liberty, but also restore some common sense.
Frankly, would this reform have meant that Rwanda flight that was grounded, not just by the European Court of Human Rights, of course, but by British courts as well, would this reform mean that that flight may have been able to take off?
I'm always careful to talk about individual cases, particularly when they're subject to ongoing litigation, but let me address it very squarely. The idea that after consideration in 3 UK courts, a so-called interim 39 order could be handed down from Strasbourg, effectively an injunction to stop the flights going, when the UK courts have said they're OK, as they did in the most recent case. That is something which our Bill of Rights will squarely address and make it clear that those orders have no effect in the UK courts.